there's something that is incorrect in your statement, I want to answer your question about ramifications. Frank's question is if there's no personal guarantee, and that would be because your EIDL loan is less than $200,000 and you are not an independent contractor and you are not a sole proprietor. That means you have the protection of what's called a corporate veil, LLC or corporate status. In that case, is there a personal consequence? Yes and no. And this is why we keep telling people, find a way to pay this loan. What are the ramifications? Well, ramifications are that this goes into collection with the U.S. Treasury, and either a collection agency or the IRS, somewhere along the line, they're going to offset tax returns and take your refunds, garnish wages if you receive a W-2 through your business. And at some point, someone is going to say to you, we need to work out a payment plan and or you've got to pay this loan back. At which point, what are your options? Attempt to negotiate an offer in compromise with the IRS or file bankruptcy and discharge the debt. We are not attorneys. This is not legal advice. This is informational only. Consult an attorney to confirm this, but we have learned from bankruptcy attorneys we've seen on YouTube that they say the EIDL can be discharged in bankruptcies. But there are other consequences, Frank, that you need to be aware of. Remember that your Social Security number, whether there's a corporate veil or not, your Social Security number is attached to that loan, which means there's a good chance you will be put on the government's DNP, or do not pay list, which means that in the future, if you get another SBA, if you apply for another SBA loan, if you go to get a mortgage that's an insured, a federally insured mortgage like the FHA, or if you're a veteran, a VA guaranteed mortgage, or a grant from the government, or if you want to become a government contractor to do business with the government, you might be, to use SBA's words, debarred from doing business with the government because of this defaulted debt. So this isn't a matter, Frank, of this appearing on your credit report. There are much more serious consequences than this going on your credit report. Those are the consequences. Now, last thing I want to address here is Frank says, I have watched people get this taken off the credit. Frank, I'm a retired mortgage banker. And I've read thousands of credit reports. Credit is one of my areas of special expertise. I'm going to tell you this about how credit works.
I'm very surprised how calm you are.
If you have a debt that is your debt and you were responsible for that debt, it can never be removed from your credit report.
Period, full stop.
And anyone who tells you that is a scam artist trying to steal your money. You cannot remove information from your credit report that is accurate. If your name is John J. Henry III and it says John J. Henry III and you decide you want the third removed, it can't be done because it's your real name. If you had a Macy's credit card that went to charge off and it was your Macy's credit card, not your Uncle Harry's, and you were a cosigner, if it was your card, it cannot be removed. Yes, these things come off temporarily.
Yes.
That's part of the scam.
They remove it while it's in dispute, but it goes right back on after maybe 60, 90 days. We have an entire playlist on credit score conundrum. Don't fall for it.
If your file is that far along with the U.S. Treasury, you should be able to file what's called an offer in compromise with the IRS/U.S. Treasury, where if you owe $200,000 and you say to them, look, I can pay $50,000 and call it a day and discharge the debt. Same as back taxes. Again, we don't know that, in fact, this is possible yet, but it should be.
Well,
because also, it is normal procedure at the IRS and Treasury to allow this type of feature.
SBA doesn't, from what I understand, and correct me where I might be wrong, if your loan is still with SBA, you don't have the offer and compromise option.
Thank you for bringing that up. You are correct.
Yes, because that is...
on a COVID-19 EIDL only.
It's a huge topic of conversation. So many people are talking about these things and what the possible solutions and strategies are, but the SBA doesn't have that capability.
For the COVID-19 EIDLs.
For the COVID-19 EIDL.
If you hear somebody telling you, oh, these two people, that guy Trevor doesn't know what the hell he's talking about, of course you can do offer and compromise. They are wrong. Yeah. You can only do an offer in compromise with the SBA for regular SBA loans.
Yes.
And again, going back to SBA's dysfunction, we have heard stories where SBA representatives are saying to people, oh, sure, we can do an offer in compromise, and sending people, business owners, the application for offer in compromise when they've got a COVID-19 EIDL. We are not attorneys.
Yeah.
And so we cannot give legal advice. The answer to your question I'm about to give you is for informational purposes only, based upon a couple of other bankruptcy attorneys I found here on YouTube. They state in their videos that a COVID-19 EIDL can, in fact, be discharged in bankruptcy. But please understand something about bankruptcy. It is not an option for everybody.
Yeah.
First of all, if you have a COVID-19 EIDL of greater than $200,000, then you're on the hook for a personal guarantee, which I think, and again, this is not legal advice, just me surmising and theorizing. I would think if your loan's more than $200,000 with a personal guarantee and you file a bankruptcy for your business to discharge the COVID-19 EIDL, you would probably also have to file a personal bankruptcy. And that is not an option for everybody.
Yeah.
I hope that answers your question, KPADS.